a lot of things about Amber Heard done by body language experts. You should not believe any of the body language experts, not even a single one of them. None of them have the background or expertise or knowledge of law or women's issues to be talking about her accusations. Not one damn one. You shouldn't believe any of them. They don't know law. I'm not sure that they know anything, and people actually give them money on Patreon. It's insane. Paul Ekman went to foreign countries where it was only tribal people who had never seen people not from their tribe and studied body language. He's like the preeminent expert on earth, as far as I'm aware. He has no equal or peer in this. And he says that when people expect not to be believed, it makes it even harder to read their body language accurately.
Founded 1852, formerly American Law Register, University of Pennsylvania Law Review, December 2017. Incredible Women, Sexual Violence and the Credibility Discount, University of Pennsylvania Law Review. Credibility is central to the legal treatment of sexual violence, as epitomized by the iconic "he said, she said" contest. Over time, the resolution of competing factual accounts has evidenced a deeply skeptical orientation toward rape accusers. This incredulous stance remains firmly lodged, having migrated from formal legal rules to informal practices, with much the same result: an enduring system of disbelief. Introducing the concept of credibility discounting helps to explain the dominant feature of our legal response to rape. Although false reports of rape are uncommon, law enforcement officers tend to default to doubt when women allege sexual assault, resulting in curtailed investigations as well as infrequent arrests and prosecutions. Credibility discounts, which are meted out at every stage of the criminal process, involve downgrades both to trustworthiness, corresponding to testimonial injustice, and to plausibility, corresponding to hermeneutical injustice. By conceptualizing prejudiced disbelief as a distinct failure of justice, one deserving of separate consideration, we may begin to grasp the full implications of credibility discounting, beyond faulty criminal justice outcomes. Attending to this failure of epistemic justice on its own terms advances a conversation about how best to reform institutions so that credibility judgments do not perpetuate inequality. To this end, credibility discounting should count as actionable discrimination under certain conditions. Moreover, this recognition raises constitutional concerns. When rape victims confront a law enforcement regime predisposed to dismiss their complaints, they are effectively denied the protective resources of the state. Rape allegations are, and always have been, deeply intertwined with questions of credibility. In the paradigmatic case of "he said, she said," accuser and accused offer two opposing versions of events. One party is telling the truth, the other is not. To pick between competing accounts, the decider must judge credibility. Accusers, typically women, do not tend to fare well in these contests. Over time, skepticism of rape complaints has remained firmly lodged, migrating from formal legal rules to informal practices, toward much the same end: the dismissal of women's reports of sexual violation. Although systemic disbelief is variegated, the staying power of what I call credibility discounting is the dominant feature of our legal response to rape. While I will later elaborate on this idea of credibility discounting, I use the term to refer to an unwarranted failure to credit an assertion where this failure stems from prejudice. Abundant evidence exists that credibility discounts are meted out at every stage of the criminal process, by police officers, prosecutors, jurors, and judges. So too are credibility discounts offered by those who form judgments about the veracity of rape accusations from outside the criminal process. This has always been true, but ongoing socio legal developments have further elevated the importance of these evaluations. One such development has been the gradual dislodging of stranger rape as archetypical, accompanied by a growing recognition that the vast majority of sexual violence is committed by an acquaintance without the use of weapons or abundant physical force. This greater awareness has in turn propelled nationwide efforts to eliminate the traditional force requirement from the statutory definition of rape. With this progression toward consent-based understandings of sexual assault, added pressure has been placed on fact-finding in cases that hinge on credibility. The difficulty of fact-finding exists regardless of how consent is defined, but controversy over affirmative consent has increased the salience of factual discrepancies while also activating the widespread perception that word-on-word, normally, he said, she said cases are not provable. For this reason, Credibility discounting threatens to stall progress toward modernizing rape law. Credibility discounting in the criminal justice system also hampers ongoing work in the campus sexual assault setting. Rather than focusing on college's obligation to provide an educational environment that allows all students, regardless of gender, to learn and thrive, policymakers are essentially asking administrators to fill a void created by a dysfunctional criminal legal process. While understandable, this impulse to work around the criminal justice system is ultimately doomed to failure. Institutions of higher education cannot substitute for the criminal justice system, but the bias perceived as endemic to criminal justice outcomes encourages resort to this alternative. Bias is not confined to the criminal justice system, of course, and campus adjudication requires university officials to assess credibility. Word-on-word scenarios are even more commonplace in the university setting, as compared to the criminal justice arena, because college disciplinary procedures lack compulsory mechanisms for obtaining corroborating evidence. Without the benefit of search warrants, subpoenas, and grand jury investigations, administrators frequently rely in full on the parties' accounts of what occurred. When these accounts diverge, as is typical, credibility discounting threatens to impair the integrity of campus proceedings. Identifying this dynamic enables a more nuanced approach to the design of college disciplinary procedures. For instance, one way of making sense of the preponderance of evidence standard, the standard that, although controversial, has now been adopted by most universities, is that it represents an attempt to compensate for long-standing and continuing credibility discounts assigned to women alleging rape on campus. Measures to target these discounts directly, if effective, might ultimately shift the calculus regarding the appropriate burden of proof. As this portrayal of legal and policy flux suggests, we are at a liminal moment for sexual assault reform both on and off campus. Because credibility discounting has the potential to thwart the evolution of sound laws and procedures regarding rape, exposing the phenomenon assumes particular urgency. This article provides a first conceptual analysis of the systemic discounting of rape accusers' credibility. It does so by situating prejudiced disbelief as a separate failure of justice, one itself deserving of consideration. Only by attending to this failure of justice on its own terms can we begin to fathom the full harm to victims, quite apart from downstream effects on criminal justice outcomes. The analysis proceeds in 4 parts. Part 1 begins by elaborating on the centrality of credibility assessment to the processing of rape allegations. Although the availability of corroborative evidence complicates conventional accounts of the he said she said model, unwarranted disbelief nonetheless undermines effective investigation and accurate adjudication. After describing this dynamic, the discussion disaggregates the construct of credibility. It then introduces the concept of discounting. Part 2 documents the phenomenon of credibility discounting. Throughout history, rape law formally embedded deep skepticism of sexual assault allegations. The systemic disregard of rape victims was accomplished through a set of unique legal requirements: corroboration, prompt outcry, and cautionary jury instructions, along with a special defense to rape for a victim's social companion. While much of this legal regime has been dismantled, credibility discounts have endured by relocating to the realm of law enforcement practice. Part 3 provides an epistemological account of credibility discounts that cast new light on the processing of rape allegations. A main contribution in this regard is to transplant the philosophical idea of epistemic injustice to legal scholarship. Epistemic injustice encompasses both the injustice of disbelief, testimonial injustice, which entails the downgrading of a speaker's perceived trustworthiness due to prejudice, and the injustice of misinterpretation, hermeneutical injustice, which prevents a person from making sense of her experience and protesting it in comprehensible form. Each category of epistemic injustice flows from structural inequalities. Each results in a primary harm and a further cascade of harms, and each pervades the criminal justice system's treatment of rape. Part 4 situates credibility discounting within law, arguing for its recognition, under delineated circumstances, as actionable discrimination. Without needing to resort to a new cause of action, I urge the application of existing anti-discrimination frameworks to the systemic provision of credibility discounts. To ground this proposal, I sketch a new equal protection claim, a claim premised on the insight that, when rape victims confront a law enforcement regime predisposed to dismiss their complaints, they are effectively denied the protective resources of the state. This article concludes by drawing attention to the political dimensions of epistemic justice and their bearing on equality norms. Because, as a general proposition, Those who are epistemically disempowered are prone to suffering unremedied injuries. Cognizing the harm of epistemic injustice holds real promise even beyond the realm of sexual violence. Incredible Women. When the listener is called upon to evaluate the truthfulness of a woman's account of rape, the listener inevitably draws upon a store of existing beliefs about rape complainants. This set of assumptions may vary by person, of course, yet if we focus on the listeners most often situated in evaluative positions vis-a-vis accusations of sexual violence, certain patterns emerge. By attending to police and prosecutors in particular, we may discern a widely shared set of background assumptions about women who allege rape. These assumptions lead law enforcement officers to disregard truthful allegations, not simply because rape and its impact on victims are misunderstood, but also because the incidence of false reporting is substantially overestimated. Recurring tropes of disbelief center on three possibilities. The rape accuser is malicious or vindictive and therefore lying about her rape. She is regretful about consenting to sexual activity with the accused and therefore lying about her rape. Or she is incapable of assessing whether she consented due to intoxication, and therefore lying when she claims otherwise. Although a rape accuser is occasionally perceived as offering a truthful account, she may nevertheless be deemed unworthy of the law's protection, either because she is seen as inviting her violation or as exaggerating the extent of her injury. Identifying this constellation of presumptions illuminates the influence of what I will call the paradigmatic rape accuser on the credibility assessments of police and prosecutors. Focus on this constellation also reveals the hold this accuser maintains on the legal rules created to inoculate against her lies and exaggerations. Before developing these observations, however, it is useful to expand upon three underlying concepts: the centrality of credibility, the components of credibility, and the meaning of discounting. The centrality of credibility. Modern-day sexual assault cases, which tend to hinge on questions of consent, are commonly perceived as he said, she said, or word-on-word contests. Yet this understanding is reductionist, for it overlooks the pivotal role of corroborative evidence. Corroborative evidence, i.e., evidence that tends to support one party's version of events, can include electronic evidence like text messages, voicemails, photographs or social media posts, forensic reports, witnesses to the lead-up or aftermath, and, on rare occasions, eyewitnesses to the incident. In addition to evidence that supports a victim's account by tending to confirm specific factual assertions, expert testimony that dispels rape myths can also be considered a type of corroborative evidence. A more holistic approach contemplates the potential availability of corroboration, which, if properly gathered, obviates the need to pit word against word. This more complicated depiction of how rape allegations are processed reveals that, for several reasons, the construct of credibility remains critical to the legal response to sexual assault. First, law enforcement officers are presented at the outset with a complainant's account of events. Only after preliminarily evaluating this account do officers decide whether and how to proceed with an investigation. Yet often, as we will see, rape accusations are promptly disregarded, short-circuiting sexual assault investigations well before the opportunity to gather available corroborative evidence is exhausted. The prevalence of truncated police investigations suggests that threshold credibility determinations are often outcome determinative. Moreover, a rape victim's willingness to report an incident to law enforcement or, in the university setting, to college administrators frequently turns on an appraisal of the probability that, as a starting proposition, she will be believed. While lacking a name for the phenomenon, survivors of sexual assault widely discern the pervasiveness of credibility discounting. Consequently, before corroboration can possibly enter the mix, most survivors opt to keep their credibility from ever being judged. Relatedly, the availability of corroborative evidence depends on the form. The promise of corroboration has its greatest purchase in the criminal context, where police and prosecutors can obtain search warrants and harness the investigative power of the grand jury. Outside the criminal context, in contrast, corroboration is generally harder to come by. This reality restricts the evidence obtainable in campus disciplinary proceedings and in any other forum without compulsory process. Last, even where a complainant's allegations are corroborated, her credibility will always matter. This observation is likely intuitive, but a few underlying points are worth noting. Corroboration, which tends to bolster a particular version of events, comes in degrees of power, from nearly definitive to extremely ambiguous. Given this spectrum, In consent cases, the probative force of corroborative evidence will almost invariably be dwarfed in importance by a victim's description of what transpired. Moreover, those charged with determining the facts will tend to interpret the significance of corroborative evidence in light of their initial assessment of complainant credibility. In short, the potential for corroboration does not alter the profound significance of credibility evaluations in rape cases. B. Components of credibility. A speaker who offers a factual claim, in philosophical parlance, a testifier, will likely be believed if she is considered trustworthy and her report deemed plausible. Each component of credibility, although often conflated in practice, should be considered separately. The first factor, trustworthiness, is perhaps most salient to our credibility determinations. Put simply, to accept the testifier's version of events, we stake our bets on the trustworthiness of the testifier. Assessments of this sort are very much rooted in the context of a given report. Consider, as just one example from the policing context, that a woman's trustworthiness might well be evaluated differently depending on whether she is reporting a rape or a robbery. As we will see, trustworthiness valuations can derive from evidence or from prejudice. When they result from the latter, the resulting downgrading of credibility raises concerns for epistemic injustice. The perceived plausibility of an account, the second foundation of credibility, is similarly grounded in a listener's pre-existing belief structures, which are often problematic. For instance, in the sexual assault context, preconceived notions of how a rape victim behaves or how rape is perpetrated, however inaccurate, inevitably inform a listener's assessment of whether an accusation is plausible. When evaluated against a store of misinformation about how the world operates, truthful reports seem strange or even bizarre. In short, each component of credibility, trustworthiness and plausibility, raises distinct epistemic dangers. See discounting. An overview. A listener engages in credibility discounting when, based upon a faulty preconception, he reduces a speaker's perceived trustworthiness or diminishes the plausibility of her account. I will later describe in depth how police officers and prosecutors discount the credibility of rape complainants. For now, a general overview of the practice will suffice. As we have already seen, inquiries into both trustworthiness and plausibility raise concerns about prejudice. But these hazards are aggravated by a tendency on the part of listeners to conflate trustworthiness and plausibility. As philosopher Karen Jones explains, testifiers who belong to suspect social groups and who are bearers of strange tales can thus suffer a double disadvantage. They risk being doubly deauthorized as knowers on account of who they are and what they claim to know. 67. The consequences of this double discounting, so to speak, are severe. Distrust puts in place a suspicious cognitive set that colors how we will interpret the words of another. It leads us to look for signs of deception, irrationality, or incompetence, and thus leads us to seek out evidence of inconsistencies, to magnify those we suppose ourselves to have found, and to focus on them in our assessment of the story as a whole. It also leads us to overlook the ways in which any inconsistencies that we take ourselves to have found can be explained away. Thus a low initial trustworthiness rating, if not insulated from affecting the assessment of the prior probability of the report, can give rise to runaway reductions in the probability assigned to a witness's story. As Jones concludes, when we violate the rule for the independence of assessments of trustworthiness and of plausibility, there is little the doubly epistemically disadvantaged can do to persuade us. We make it impossible for them to convince us by words of the truth of what they say. We can further refine this explanation of credibility discounting in two ways. First, while there is some disagreement about whether credibility is a finite good, under certain circumstances, notably the word-on-word case, a determination that one party is worthy of belief requires a judgment that the other is not. This scenario raises the prospect that one party might be afforded greater credibility than is warranted by the evidence. 71. Consider that where A accuses B of raping her and B denies doing so, a prejudiced listener's credibility determination might assume one of three of forms. A is downgraded and B is upgraded. A is downgraded and B is properly assessed. A is properly assessed and B is upgraded. All of these possibilities fall under the rubric of credibility discounting, as I employ the term. To further complicate the picture, credibility estimations fall along a continuum of belief. This suggests that discounting is not an all-or-nothing proposition. A speaker might receive a slight downgrading, a sizable downgrading, or anywhere in between. Acknowledging the existence of the credibility discount is not the same as insisting that all rape allegations are true. The problem that I identify here is a profound disconnect between perceptions of falsity and actual falsity. Before we further probe this disconnect, ask yourself, what percentage of rape accusations reported to the police are false? In one survey of nearly 900 police officers, more than half of the respondents stated that 10 to 50% of sexual assault complainants lie about being assaulted, while another 10% of respondents asserted that the number of false reports is FIFY 200%. Another study found that more than half of the detectives interviewed believed that 40 to 80% of sexual assault complaints are false. This openly manifested skepticism largely explains the unusually high unfounding rates that characterize the police treatment of rape allegations. Research on false rape allegations suggests that such skepticism is unwarranted. Admittedly, studying the prevalence of false reports is difficult because of the methodological challenge of identifying ground truth, a difficulty that largely accounts for significant discrepancies in findings. As one researcher aptly summarized the problem, significant adherence to rape myths by the public, media, jurors, and the criminal legal system makes it practically impossible to unravel the highly layered truth about false rape allegations. One major limitation of the research is its frequent reliance on official law enforcement documents to classify an allegation as false, equating a police determination that an accusation is unfounded with the falsity of that accusation results in the uncritical adoption of any and all credibility discounts meted out in the course of an investigation. Yet researchers often fail to note, much less to disentangle, this effect. Another common methodological flaw is to equate an accuser recanting with a false accusation. Since many factors may cause a truthful complainant to recant her allegation, a failure to independently assess the underlying accusation tends to result in findings of false reporting rates that are misleadingly high. In short, methodological shortcomings in this area are rampant. The best available research on false allegations involves an independent evaluation of reports deemed unfounded by police. 86. The prime example is a 2012 study of a random sample of cases classified as unfounded by the Los Angeles Police Department, LAPD, in a single year. For each of the 81 cases investigated, researchers reviewed the complete police file, including the initial report prepared by the responding patrol officer, all follow-up reports from the assigned detective, and the detective's reasons for classifying the report as unfounded. Researchers divided reports ultimately determined to be false into two categories: cases in which the complainant recanted and there was evidence to support a conclusion that a crime did not occur, and cases in which the complainant did not recant but there was either evidence that the crime did not occur or no evidence that the crime did occur. Of the 81 cases determined to be unfounded by police, 55 were deemed by researchers to have been false reports. After comparing this number to the total number of sexual assault complaints made to the LAPD that year, researchers calculated that 4.5% of all cases reported to the LAPD that year were false. Another study that adopted a similar methodology is a 2010 review of all sexual assault cases reported to a major northeastern university over a 10-year period. The number of cases totaled 136.93, defining a false claim as one in which a full investigation took place 94, and the evidence showed by a preponderance that the reported sexual assault had not occurred. Researchers found that only 8 cases, 5.9% of the reported sexual assaults, were false reports. 95. In half of the allegations deemed by the research team to be false, the alleged victim ultimately admitted to fabricating some or all of their claims. A different approach trains police officers to more accurately and precisely classify reports, then assesses the prevalence of allegations officers deem false. This methodology was employed by the only multi-state study to evaluate the incidence of false reports. Law enforcement agencies in 8 U.S. communities collected data for all sexual assault reports received over an 18 to 24-month period, a total of 2,059 cases. Participating agencies received training in how to properly classify sexual assault cases, along with technical assistance to help ensure consistency and reliability. These efforts were designed to reduce the effects of law enforcement biases. The study found a slightly higher incidence of false reports. 140 of the 2,059 cases, 6.8%, were classified as such, as compared to research relying on an independent assessment of the allegations. In sum, among these studies, which require a reasonably sound basis to believe that an allegation is false before classifying it accordingly, we see false reporting rates of 4.5%, 5.9%, and 6.8%. These figures are significantly lower than those provided by law enforcement officers when asked to estimate the incidence of false reporting. Moreover, research suggests that the kinds of cases most likely to be considered false, namely, those involving non-strangers and those involving intoxication, are in fact least likely to be false. Relatedly, commonplace assumptions on the part of law enforcement officers regarding rape accusers' motivations are misguided. Even in false reports, revenge, regret and guilt are not usually factors. Law enforcement practices are steeped in misconceptions about the truthfulness of women alleging sexual assault. We now consider how pervasive skepticism is expressed in the meaning out of credibility discounts. 2. Mapping the credibility discount. The legal response to rape has long been shaped by entrenched disbelief of women who level accusations of sexual assault, with one important exception. That is, for cases of white women alleging rape by black men, the criminal justice system has generally treated rape complainants with incredulity. For much of American history, this distrust was openly baked into the law. Although modern reform efforts have mostly succeeded in abolishing formal rules of disbelief, the intuition behind these rules persists today, coalescing in an expansive enforcement gap. Scrutinizing the justificatory rhetoric underlying traditional legal doctrine enables us to track the migration of credibility discounts from formal legal process to law enforcement. In turn, tracing the origins of contemporary misgivings about rape allegations to repudiated legal structures provides purchase on why and how systemic incredulity endures. A incredulous law. American law has long embodied a stance of overt suspicion toward rape accusers. By examining both the common law and the model penal code, we can disaggregate several related concerns about the woman alleging rape, specifically, her motivation to lie, her comparative fault in the rape, and the de minimis nature of her resulting injury. Our legal rules were designed to protect against this lying, inviting, exaggerating complainant, or the paradigmatic rape accuser, as I have described her. Her specter haunts rape law, from corroboration requirements, to prompt outcry rules, to cautionary jury instructions, to substantive definitions of crime and defense. 1. Corroboration requirements, prompt outcry rules, and cautionary jury instructions. To make the crime of rape more difficult to prove, a set of rules required, in various permutations, corroborative evidence of the alleged victim's account, the alleged victim's prompt disclosure of the incident, and jury instructions warning the jury about the danger of wrongly convicting the defendant. The history of these requirements is telling, as it reveals deeply ingrained doubts about the veracity of women alleging rape. For instance, when New York first enacted a special corroboration requirement in 1886, it did so to shield defendants from untruthful, dishonest, or vicious accusers. Other states soon adopted this approach, including Georgia, whose Supreme Court proclaimed that, without a corroboration requirement, every man is in danger of being prosecuted and convicted on the testimony of a base woman in whose testimony there is no truth. Likewise, the requirement of a prompt complaint rested on a presumptive distrust of rape allegations. Writing in 1900, the Utah Supreme Court equated delayed reporting with falsehood. The natural instinct of a female thus outraged and injured prompts her to disclose the occurrence, at the earliest opportunity, to a relative or friend who naturally has the deepest interest in her welfare, and the absence of such disclosure tends to discredit her as a witness. Perhaps the starkest expression of the law's orientation toward rape accusers were jury instructions explicitly warning the jury to use special suspicion in evaluating the testimony of a rape complainant. Based on the 17th century ruminations of Lord Hale, cautionary instructions sought to ensure jurors would remain particularly distrustful of the complainant's version of events. In the parlance of one typical pattern instruction, since a rape charge is one which is easily made and, once made, difficult to defend against, even if the person accused is innocent, the law requires that you examine the testimony of the female person named in the information with caution. The Model Penal Code, MPC, which includes a corroboration requirement, a rigid prompt outcry rule, and cautionary jury instructions, incorporates intense mistrust of rape complainants. Familiar rationales underlie the MPC's skeptical stance toward allegations of sexual assault. In order to defend the exceptional requirement of corroboration, The commentary cites the difficulty of defending against false accusation of a sexual offense, while explaining that the corroboration requirement is an attempt to skew resolution of word-on-word disputes in favor of the defendant. To justify a hard prompt outcry rule, the commentary references a vindictive complainant, along with the dangers of blackmail or psychopathy of the complainant, and to rationalize an instruction that tells jurors to evaluate the testimony of a victim with special care. The MPC relies on the emotional involvement of the witness and the difficulty of determining the truth with respect to alleged sexual activities carried out in private. The MPC provisions on sexual assault are currently undergoing long overdue revision, and most though not all jurisdictions have already abolished formal rules of disbelief. Even so, as we will see, these same requirements are now imposed informally, yielding credibility discounts that are in many respects the functional equivalent of their legal predecessors. 2. Substantive definitions of crime and defense. About two-thirds of the states still rely on the concept of force in criminalizing rape. Many jurisdictions expressly define rape as requiring physical force, a term that, for purposes of rape law, generally means more force than the force inherent in the act of intercourse. Other states define rape as sex without consent but include force as a component of non-consent. In short, across the majority of states and in various guises, the force requirement endures. This requirement has been heavily critiqued, and my purpose here is not to retread well-covered ground. Rather, I wish simply to observe that, among the many functions performed by a force standard, one is to serve as the ultimate corroboration requirement by insisting, as a matter of law, that an accuser's testimony regarding her lack of consent be bolstered by proof beyond a reasonable doubt of a separate, more objective element. On this view, the traditional and still prevalent definition of rape embodies grave misgivings about a rape complainant's say-so. This perspective finds resonance in the MPC, which defines rape by reference to Force 139 and justifies this treatment by tacitly invoking the paradigmatic accuser, her lying, inviting and exaggerating. As the commentary explains, often a woman's attitude may be deeply ambivalent. She may not want intercourse, may fear it, or may desire it but feel compelled to say no. Her confusion at the time of the act may later resolve into non-consent. Some have expressed the fear that a woman who subconsciously wanted to have sexual intercourse will later feel guilty and cry rape. The same set of concerns lies behind the MPC's recognition of a voluntary social companion defense to rape. The defense codifies the view that, as compared to stranger rape or real rape, non-stranger rape is less violative and more problematically dependent on subjective forms of evidence, namely, the testimony of an accuser. The commentary describes the rationale for the defense as follows. First, when previous sexual liberties have been allowed and the persons involved are voluntary companions on the occasion of the offense, the gravity of the wrong is arguably less severe. Second, the fact that the actor is a stranger to the victim, or the fact that sexual liberties have not been permitted in the past, is strong objective corroboration of the fact that the sexual act was accomplished by imposition. The criterion is thus consistent with the efforts of the Model Code to avoid making the imposition consent inquiry entirely on a subjective basis and to seek objective indicia to support the necessary finding of compulsion. This commentary reflects an understanding of the non-stranger rape accuser as not only less than violated, but also less than credible. In recent decades, progressive law reform has undone most rules that formally discount the credibility of rape accusers, and this trajectory continues. Yet, to this day, the logic of the forcible compulsion standard and of the voluntary social companion defense influence how rape law is enforced, and the basic assumptions underlying the corroboration requirement, the prompt outcry rule, and cautionary jury instructions persist in new guises. We turn now to current incarnations of the credibility discount. Be incredulous law enforcement. In the field of law enforcement, where vast discretion is afforded to those charged with the investigation and prosecution of crime, wide-ranging impulses to downgrade the credibility of rape accusers find a capacious outlet. Informal practices quietly sustain a regime that disadvantages those seeking criminal justice redress for sexual violence, and serve as a substitute for the formally disavowed legal rules crafted to achieve this same end. In the policing arena, we can discern the appearance of the paradigmatic accuser, who, either in the alternative or in combination, invited the alleged rape, was not harmed by it, and did not in fact experience it. Again, Disbelief stems from three possibilities. The complainant is malicious or vindictive. She is regretful about consenting to sexual activity with the accused, or she is incapable of assessing whether she consented due to intoxication. Although false reports of rape are uncommon, law enforcement officers often default to incredulity when women allege sexual assault, resulting in curtailed investigations and infrequent arrests. Prosecutorial charging practices are less easily tracked, but evidence shows that credibility discounts are also imposed at this stage of the criminal process. Indeed, the effects of systemic disbelief extend beyond the estimations of individual prosecutors, because prosecutors consider the likely reaction of jurors when evaluating whether to proceed with a case. Personal credibility reductions are compounded by a calculus about the layperson's biases. I will refer to this dynamic as anticipatory discounting. But first, we examine practices of credibility discounting in the policing of sexual assault. 1. Police. A majority of sexual assault victims preempt the deployment of credibility discounts by declining to relate the crime's occurrence to law enforcement officials. According to recent Justice Department estimates, the population most vulnerable to sexual assault, females ages 18-24, report to police at rates of only 20% for college students and 32% for non-college students. Women of color, both on and off campus, may be even less likely to report sexual assault than their white counterparts. One reason is the predictability of a non-response. Among non-students, nearly 1 in 5 surveyed did not report because police would not or could not do anything to help. Rape survivors are mostly foregoing the criminal justice system in anticipation of how their case will be mishandled. The widespread perception that police are unlikely to pursue allegations of non-stranger rape is often accurate. Little has changed since a 1997 survey demonstrated the unfounding, or deeming unsubstantiated, of rape allegations at disproportionately high rates while detailing the salient operation of police biases, especially in cases involving acquaintances. Recent empirical research on policing consistently establishes the disparate treatment of rape, and failures to investigate sexual assault cases have been well documented. Consistent with this nationwide data, police have systematically mishandled rape cases in jurisdictions including Los Angeles, Baltimore, St. Louis, New Orleans, New York, Salt Lake County, Philadelphia, and Missoula, Montana. While the poor treatment of rape cases by police is generally rampant, police responses to sexual assault are particularly defective in cases involving women of color, immigrants, LGBTQ individuals, women in poverty, and sex workers. Officers' premature closings of rape investigations frequently at the initial stages, along with unfounding allegations at disproportionately high rates, are byproducts of credibility discounting. On occasion, law enforcement officers make explicit their priors regarding the probability that a rape allegation is false. For instance, in March 2016, explaining his resistance to a law that would require the testing of sexual assault kits, an Idaho sheriff asserted that the majority of our rapes that are called in are actually consensual sex. Similarly, in late 2015, a police chief at a Georgia college noted that most of these sexual assaults are women waking up the next morning with a guilt complex. That ain't rape, that's being stupid. When the dust settles, it was all consensual. While it is rather unusual for law enforcement officers to publicly acknowledge and endeavor to legitimate systemic disbelief, studies indicate that skepticism of rape accusations is endemic. There is also abundant anecdotal evidence that police officers are discounting complainant credibility when responding to allegations of rape. Consider, as just one example, the case of Laura McLeod, who in 2011 was arrested for falsely reporting her rape before the charges were ultimately dropped. From the beginning, the detective who first interviewed McLeod appeared to doubt her claims. Later, internal police documents and recordings would show how grievously the police botched their investigation from start to finish, allowing their beliefs about sexual assault to influence the way they pursued the case. In the end, with McLeod's alleged rapist still uncharged, the police chief admitted that the investigation had been shortcutted while taking pains to underscore that women do lie about rape, so it was important for officers not to be too credulous. The chief added that it is not uncommon for people to make false, malicious, salacious allegations of sexual assault. The typical law enforcement investigation is guilt presumptive and potentially problematic for that reason. In sexual assault cases, this presumption is flipped. Investigators start from the proposition that the complainant is lying and act to confirm this belief. As the McLeod case demonstrates, the starting point and path to confirmation in rape cases are mere images of typical investigations of other types of crime. Credibility discounting by police investigators curtails the collection of corroborative evidence that might otherwise mitigate the effects of downstream credibility discounts. Untested, rape kits are concrete substantiation of this practice and emblematic of dismissive attitudes towards sexual assault allegations. A 2015 study of the policing of sexual violence in Detroit provides the most thorough examination to date of untested or shelved rape kits. A rape kit, or forensic sexual assault examination, collects and preserves evidence obtained through an invasive physical examination of the victim, including hair, fibers, semen, saliva, skin cells, and blood. Importantly, the Detroit study offers an in-depth analysis of why police officers fail to test rape kits. What researchers discovered is that cases where suspect identity was not an issue, that is, cases involving non-strangers, were typically not considered worthy of investigation. In hundreds of interviews, police officers indicated that the failure to submit a rape kit for testing was reflective of a decision not to pursue the case. Put differently, the kits were shelved because the allegations had already been disregarded, not because the case was perceived as sufficiently strong even without the kit. As researchers explained, in many respects, the untested kits were a tangible sign about the dispositions of these cases. The case had been shelved, figuratively. The kit had been shelved, literally. As one police official put it, the kits that weren't tested were cases that we couldn't or wouldn't do anything about. Frequently, officers would disbelieve victims who knew their assailants. Police doubted victims' credibility if they knew or were even minimally acquainted with the assailant. When asked how common it was that known associates, friends, and/or partners rape their partners, police acknowledged that it does happen, but, in their belief, not that often. Officers' accounts of why they dismiss rape allegations were remarkably consistent with long-standing conceptions of the paradigmatic rape accuser. A repeatedly expressed concern was that rape accusations are simply revenge reports. For instance, as one officer related, "I don't have time to deal with, wake up and regret. You did what you did. That's that. It's not a crime and don't take up our time with it." The regret trope is premised on a notion that consensual sex is often ruled in retrospect. This lament is perceived as the impetus for fabricating rape accusations. Another prevailing sentiment is that, under certain circumstances, sex, with or without consent, is inevitable. According to researchers, many police officers suggested that victims ought to expect what they get if they invite someone over or agree to go somewhere with them. As one investigator stated, "It might not be right, but it's what happens. You go over there, what do you think's gonna happen?" By placing blame on the victim, investigators directly shift responsibility away from the rapist. Related to this blaming tactic is an urge to discount the harm of non-stranger rape. In interviews, this impulse was often cloaked by reference to the difficulties of disproving the defense of consent. But in actuality, investigators were deciding that the investment of time and effort in successfully closing a case was not worth the payoff. This implicit trivializing of acquaintance rape appears grounded in an intuition that rape within a relationship or acquaintanceship does not cause serious injury, likely because consent as a dividing line between sex and rape is not seen as all that significant. Remark on the "he said, she said" nature of non-stranger cases is thus readily deployed to justify police refusal to investigate allegations that, even if provable, are deemed insufficiently serious to warrant the necessary expenditure of law enforcement resources. 2. Prosecutors. Even when police found a rape complaint, prosecutors often choose not to pursue the case. To understand why prosecutors charge only a fraction of the sexual assault cases referred to them and how credibility discounts function at this stage of the process, we begin by considering the discretion generally afforded prosecutors. Prosecutors make several key determinations, chief among them whether to charge a defendant with a crime. The various rules that apply to prosecutorial charging reference fairly low thresholds of evidence, including probable cause and evidence sufficient to support a finding of guilt. In practice, however, prosecutors generally impose far more stringent standards on the decision to proceed with charges, including the belief that the case would likely result in a conviction at trial. The convictability standard, as it is known, requires prosecutors to consider not just whether jurors could convict based on the admissible evidence, the sufficiency standard, but whether jurors would probably do so. In order to reach this conclusion, prosecutors endeavor to predict how jurors would likely evaluate the proof at trial, including the credibility of the complainant. Although this inquiry is not generally sanctioned, it is unsurprising that prosecutors with limited resources, and, less admirably, concerns about conviction rates, often incorporate the expected reaction of jurors into charging decisions. A prosecutor's determination not to charge a defendant may thus encompass not only his or her own personal skepticism, but also anticipatory credibility discounting. Prosecutorial charging in sexual assault cases, especially those involving acquaintances, is inexorably linked to concerns, whether well-founded or not, that jurors will downgrade the accuser's credibility. As one prosecutor stressed, the bottom line is whether the jury will believe the victim. Rape cases rarely involve witnesses and don't always involve physical evidence, so it all comes down to the victim and her credibility. It is difficult to know the extent to which these concerns provide cover for prosecutors themselves to engage in this discrediting. Put differently, we cannot tell who precisely is wronging the complainant by discounting her credibility, the prosecutor or the imagined fact finder. For present purposes, however, this distinction matters less than the outcome generated by the prosecutor's ostensible reliance on the jury's expected response. Even if this reliance is genuine or correct, it results in systemic credibility discounting. Prosecutors' explanations for their reluctance to charge word-on-word rape cases provide considerable support for the significance of downstream discounts. For instance, one prosecutor acknowledged that her office does consider jury bias when determining whether to prosecute, adding that a lot of the cultural attitudes about sexual assault come into play in a jury trial and are part of the consideration about whether or not we would be able to prove it beyond a reasonable doubt. Quantitative and qualitative research on prosecutorial charging practices is consistent with this account. Studies have demonstrated that convictability is the organizational standard on which prosecutors file cases. Anticipatory credibility discounting in rape cases is intersectional, as prosecutors contemplate a range of demographic characteristics perceived as relevant to the likelihood of juror belief. This calculus draws on a stock of narratives that incorporate stereotypes of real crimes and credible victims. In sum, framed by an inquiry into how the archetypical juror would assess the complainant's account, prosecutorial decision-making transposes the widespread acceptance of rape myths into a legitimate rationale for declining to pursue charges. The explanations provided by prosecutors for their charging decisions show that the paradigmatic rape accuser, she who lies and invites her rape, is often deployed to justify discounted credibility determinations. Invoking the inviting complainant, for instance, one prosecutor noted that, in non-stranger cases, jurors typically have questions about her behavior at the time of the incident. Why did she agree to go back to his room after the date? Why did she agree to watch pornographic movies with him? And so on. Conjuring the liar in order to defend a starting point of disbelief, one prosecutor urged, "We have to recognize that there are situations in which people make false allegations. A woman may be angry at her husband, who is having an affair, and may see this as a way to get back at him. Or, a woman may falsely claim that she was raped in order to cover up a premarital or extramarital sexual relationship or to explain away a sexually transmitted disease or pregnancy. In these situations, you have to determine whether the victim is being truthful. You have to see if there are circumstances that allow you to conclude that the allegation is real. Overall, the prosecution of sexual violence is burdened by compounded credibility discounts, resulting in the assumption that jurors will prove unwilling to convict based on the complainant's testimony. Where expected juror skepticism is the effect of prejudice, a subject to which we will shortly turn, prosecutor deference to the likely trial outcome begets epistemic injustice. 3. Theorizing the credibility discount integral to the criminal justice system's response to sexual assault is the practice of what I am calling credibility discounting. To conceptualize this practice, I draw on the idea of epistemic injustice developed in Miranda Fricker's seminal work, Epistemic Injustice, Power and the Ethics of Knowing. In recent years, Fricker's framework has become quite influential in philosophical quarters while barely penetrating the legal academy. Epistemic injustice is a distinctive type of injustice in which a person is wronged in her capacity as a knower. Because each of us is socially situated, our judgments about which claims to credit are bound up in power and, often, prejudice. Fricker identifies two types of epistemic injustice. testimonial and hermeneutical, which together provide a useful vantage on the practice of credibility discounting in sexual assault cases. Failures of belief. Broadly speaking, testimonial injustice occurs when a credibility assessment results from prejudice. The use of testimony in this context does not correspond to its legal meaning, it simply refers to the effort to communicate a factual assertion. Although prejudice can sometimes lead to unwarranted elevations of credibility, testimonial injustice is defined by unwarranted credibility reductions. With this kind of epistemic dysfunction, prejudice will tend surreptitiously to deflate the credibility afforded the speaker, and sometimes this will be sufficient to cross the threshold for belief or acceptance so that the hearer's prejudice causes him to miss out on a piece of knowledge. Integral to this conception is the idea of prejudice, which mainly enters a testimonial exchange via stereotypes that we make use of as heuristics in our credibility judgments. In accordance with what social psychology tells us about human decision-making, stereotypes can be defined as empirical generalizations about a particular social group. Although these generalizations may in theory be reliable, in social practice the stereotypes we rely upon are often unreliable or prejudiced. Moreover, consider the impact of power and group identity on the deployment of familiar stereotypes. As Fricker observes, many of the stereotypes of historically powerless groups such as women, black people, or working-class people variously involve an association with some attribute inversely related to competence or sincerity or both, emotionality, illogicity, inferior intelligence, evolutionary inferiority, incontinence, lack of breeding, lack of moral fiber, being on the make, etc. A first thing to say about such prejudicial stereotypes is that insofar as the association is false, the stereotype embodies an unreliable empirical generalization about the social group in question. Negative identity prejudice, as Fricker calls it, is especially concerning because it tends to be resistant to counter-evidence. This is not to suggest that prejudicial stereotypes are consciously maintained and mobilized in our epistemic exchanges. Just the opposite is true. Even so, being situated in a structurally unequal social landscape, one in which group identities shape individual relations, cannot but impact how we make sense of the world. Of course, the normalcy of testimonial injustice does not negate its wrongfulness. Most glaring in this regard is the purely epistemic harm that occurs when knowledge that should be imparted to a hearer is irrationally rejected. Not only does the hearer experience a truth deficit, but so too does the epistemic ecosystem in which the hearer is embedded. Consider, for instance, a police officer's resort to a negative identity prejudice to evaluate a rape accuser's credibility. If the initial report is perceived as false, there may be no further investigation. The case will be closed based on faulty factual premises. Even apart from the disadvantage that flows to the hearer and the epistemic ecosystem of which the hearer is part, the speaker is significantly harmed in her capacity as a knower when she experiences testimonial injustice. This harm, a primary harm, in Fricker's terms, has gone largely unnoticed in legal discourse. To describe the contours of the primary harm, we might begin by observing that a speaker whose capacity as a knower is undermined has been, in important respects, dehumanized. Rationality is a core feature of humanity. The capacity to share knowledge is essential to human value. In its darkest iteration, to deny one's capacity as a knower then is to deny one's humanity. As Fricker argues, the fact that the primary injustice involves insult to someone in respect of a capacity essential to human value lends even its least harmful instances to police one's beliefs for prejudice. It is significantly harder reliably to filter out the prejudicial stereotypes that inform one's social perceptions directly. Symbolic power that adds a layer of harm of its own. The epistemic wrong bears a social meaning to the effect that the subject is less than fully human. When someone suffers a testimonial injustice, they are degraded qua knower, and they are symbolically degraded qua human. In all cases of testimonial injustice, what the person suffers from is not simply the epistemic wrong in itself, but also the meaning of being treated like that. The treatment of a subject as incapable of giving knowledge is a form of objectification, which often induces the would-be speaker's silencing. This silencing can take more than one form. At times, an objectifying stance on the part of the hearer leads to a failure of uptake that prevents the words from registering as communication. At other times, hearer prejudice preempts a testimonial exchange altogether, denying a victim of testimonial injustice the very opportunity to speak. This latter dynamic, variously referred to as Preemptive testimonial injustice or testimonial smothering keeps a would-be speaker from ever sharing her account. All told, testimonial injustice tends to exacerbate oppression, not only of the speaker herself, but also of the prejudged groups to which she may belong. Because prejudice is commonly rooted in structures of power, the suppression of knowledge overwhelmingly disadvantages those who are already subordinated. Failures of understanding hermeneutical injustice undermines one's ability to make sense of certain experiences, typically, experiences not shared by those with greater power to shape the realm of interpretation. As we will see, hermeneutical injustice and testimonial injustice overlap in important respects. But before exploring this intersection, it is useful to isolate the unjust failures of understanding that characterize the realm of hermeneutical injustice. A starting premise is that power influences the ability to participate in the construction of social experience. As a result, particular areas of social life, hermeneutical hotspots, come to be defined by markedly unequal participation in the construction of meaning. This hermeneutical marginalization, as Fricker describes it, is problematic because it renders the collective hermeneutical resource structurally prejudiced. As examples, Fricker cites the framing of sexual harassment as flirting, rape and marriage as non-rape, postnatal depression as hysteria, reluctance to work family unfriendly hours as unprofessionalism, and so on. Rape myths too are a type of hermeneutical injustice. What these illustrations reveal is that membership in a group with relatively scant social power can correspond to a distinct hermeneutical disadvantage. Experiences not shared by the powerful find no meaningful outlet in collective notions of reality. This is the essence of hermeneutical injustice. The structural disadvantage that undermines the ability to make sense of an experience varies along multiple axes. First, a collective misunderstanding can deviate from the subject's interpretation to greater or lesser extents. Next, the subject may not understand her own experience adequately, or if she is able to communicate it to similarly situated group members, she nonetheless may be powerless to convey it to the community at large. Last, the subject might find herself epistemically disadvantaged by the collective's misunderstanding of the content of her experience or by the form in which that content is expressed. Regardless of how it manifests, hermeneutical injustice renders a member of the discriminated against group unable to make communicatively intelligible something which it is particularly in his or her interest to be able to render intelligible. As a result, the would-be speaker is unfairly excluded from participating in the spread of knowledge. This, as we have already seen in the context of testimonial injustice, represents a profound primary harm. Finally, we arrive at the junction of testimonial and hermeneutical injustices. To see how the two converge in a double epistemic injustice, let us take up the question of timing. When precisely does a hermeneutical injustice occur, particularly since a subject's exclusion from the collective knowledge pool is ongoing? Fricker pegs the injustice to the moment when the would-be speaker confronts the practical impossibility of conveying her experience to the wider world. This insight suggests that members of marginalized groups tend simultaneously to confront the deflation of their own credibility and a collective misunderstanding of the experience sought to be communicated. When this happens, the speaker is doubly wronged. Testimonial injustice is thus exacerbated by hermeneutical injustice and vice versa. This returns us to the credibility discount, which lies at the nexus of both categories of epistemic discrimination. IV. Discounting as discrimination. Thus far, I have described the phenomenon of credibility discounting, identified it as a widespread form of law enforcement practice and argued that it constitutes an unrecognized type of injustice that results in overlooked harm. Here, I urge the legal redress of this harm by defining credibility discounting as potentially actionable discrimination. Toward legal redress only after an injury is identified as such can the question of legal redress be contemplated, thereby refashioning the meaning of the violation. Among the most dramatic illustrations of this dialectic is sexual harassment, which once was largely invisible as an experience, but ultimately became a cause of action. The example underscores the power of law to transform a widely pervasive social practice. For present purposes, the analogy is also instructive for other reasons. Like sexual harassment, credibility discounting, in the sexual assault context and beyond, is a form of discrimination based on group membership. This is not to say that credibility discounting is only a form of discrimination. It might additionally be a tort, for instance. But the discrimination rubric provides an especially nice fit, as it captures the social dimensions of the practice, along with its inequality-perpetuating features. To conceive of credibility discounting as a form of discrimination that should be actionable under certain circumstances raises a host of questions, the answers to which are largely dependent on context. As a general proposition, discriminatory conduct has varying legal consequences and available redress, depending on the actor and the setting. For instance, behaviors that might otherwise be considered sexually harassing are legally cognizable only in certain contexts, primarily the workplace and school environs, and not in others, say, the street. Likewise, a rape accuser might find redress for credibility discounting by a police detective or campus administrator, but not a skeptical neighbor. Moreover, even where behavior is considered actionable discrimination, what precisely the law prohibits varies. On campus, discrimination that undermines educational opportunity is the problem. In the workplace, discrimination that interferes with the job matters, and in the criminal justice system, discrimination that distributes protection unequally is prohibited. Returning to the discrimination at issue when credibility is discounted, rape complainants should rely on federal civil rights guarantees, Title IX in particular, when discounts are meted out on campus. Systemic skepticism of claims of sexual violations constitutes discrimination on the basis of sex, which federal law prohibits. Most germane to the law enforcement context, rape complainants should rely on the constitutional guarantee of equal protection when law enforcement officials engage in credibility discounting. I now develop this equal protection argument. B. Credibility discounting as unequal protection. To ground the claim that credibility discounting should count as unlawful discrimination under existing jurisprudential frameworks, I turn to the doctrinal setting most appropriate to address credibility discounting by police departments in particular. By outlining the parameters of an equal protection claim, specifically, I aim to begin a conversation about how best to translate the theory, credibility discounting as discrimination, to law. Given this ambition, I set aside legitimate critique of existing equal protection jurisprudence. Rather, I show how the articulation of a separate form of discrimination might work in practice. I do so by analyzing a lawsuit currently pending in federal district court. My contention is that alleging a practice of credibility discounting would bolster the plaintiff's failure to protect claim. By contemplating the contours of this augmented claim, we can begin to envision a model for future equal protection litigation. Ultimately, this more robust legal response can help to delegitimate practices of discounting that remain commonplace, propelling much-needed cultural transformation. On May 16, 2010, Heather Marlowe and a group of her friends attended San Francisco's Bay to Breakers race. According to her complaint, while at Bay to Breakers, Marlowe was handed a beer in a red plastic cup by a male attendee, and Marlowe drank the beer. Subsequently, Marlowe began feeling much more inebriated than would have been normal given her moderate alcohol consumption up to that point. Marlowe regained consciousness inside an unfamiliar home approximately 8 hours after she was last seen at Bay to Breakers. Marlowe was physically injured, experienced vaginal and pelvic pain, was nauseous and vomited several times, was dazed, confused, and had no memory of what had occurred in the house. Marlowe asked a man sitting in the bed with her what had happened. The man told Marlowe, "We had sex." At this point, Marlowe realized that she had been drugged and raped. Soon after, Marlowe went to the nearest emergency room, where a specially trained nurse collected a rape kit. The San Francisco Police Department, SFPD, which took Marlowe's report at the hospital, indicated that the evidence would be processed in the next 14 to 60 days. The following week, Marlowe performed a Google search for the person she believed had raped her. It is unclear from the complaint how she was able to draw this connection. After locating a picture of a man that resembled her memory of the rapist, Marlowe contacted police officer Joe Cordes, the SFPD officer investigating her allegation. According to the complaint, Cordes responded by instructing Marlowe to make contact with suspect, and flirt with him in order to elicit a confession that suspect had indeed raped Marlowe. Cordes also instructed Marlowe to set up a date with suspect to prove that Marlowe could identify suspect in a crowd. Cordes told Marlowe that, if she refused to engage in this action, SFPD would cease its investigation of her rape. When Marlowe later met with Cordes to clarify what he wanted her to do, Cordes strongly discouraged Marlowe from further pursuing her case, indicating that it was too much work for the SFPD to investigate and prosecute a rape in which alcohol was involved. Eventually, after repeatedly attempting to set up the date, as Cordes had instructed, Marlowe contacted Cordes to inform him that she refused to continue to privately investigate her case. Only then did SFPD inform Marlowe that the suspect had been taken in for questioning and his DNA sample collected. Marlowe was told that the suspect's DNA was being processed at the lab, and that her rape kit results would be available shortly. Over the course of the next 2 years, Marlowe unsuccessfully saw testing of her rape kit. At one point, Marlowe was told that due to the passage of time, her case was considered inactive and was placed in a storage facility. SFPD also told Marlowe that because she was a woman, weighs less than men, and has her menstruations, that Marlowe should not have been out partying on the day of the incident. When her kit was finally tested, Marlowe discovered that her experience was not unusual. In 2014, after first denying the existence of a backlog, SFPD acknowledged that several thousand rape kits dating back to 2003 remained untested. Marlowe sued the city of San Francisco, along with various top police officials, alleging a violation of equal protection and seeking damages and injunctive relief. The complaint charges that the police department had the policy, practice and/or custom of failing to diligently investigate sexual assault allegations, as evidenced by its failure to test thousands of rape kits. Regardless of whether Marlowe ultimately prevails, it is worth observing that, even on its face, her claim is sufficiently broad to encompass far more than the shelved rape kits. Although Marlowe's complaint focuses on SFPD's failure to test her rape kit, she could, and perhaps would, were the case ever to proceed to discovery and trial, provide a rich chronicle of why her allegations were deemed unworthy of investigation. We see glimpses of this discounting already. She invited her rape by drinking too much. Her account of having been drugged is dismissed. Her casual acquaintance with her alleged rapist is perceived as a mitigating factor, but there is far more to say about the deep skepticism that led not only to the police refusal to test her rape kit, but to its decision to place her case on inactive status. Perhaps more important, expanding the allegations to encompass SFPD's practice of credibility discounting substantially strengthens the case for discrimination. To succeed on the merits, Marlowe must demonstrate that she was provided an unequal measure of police protection, at least in part, because she is a woman. The existence of shelved rape kits is relevant to this claim, but it is only part of the story of how sexual assault survivors confront a law enforcement regime predisposed to dismiss their complaints. Recall the Detroit Sexual Assault Kit Action Research Project, which established that the failure to submit a rape kit for testing meant that the police had already decided not to pursue an investigation. As demonstrated by this study and others like it, shelved rape kits result from credibility discounting. Indeed, they are powerful, tangible evidence of it. Incorporating this deeper causal account into claims of unequal protection exposes the discrimination driver. Conclusion: credibility discounting is a pervasive feature of our legal response to rape. Even today, rape accusers remain subject to a pronounced credibility discount. This discount involves downgrades both to plausibility, corresponding to hermeneutical injustice, and to trustworthiness, corresponding to problems of testimonial injustice. Point 329. By surfacing the discounting phenomenon, I have endeavored to give content to its practice, first by reviewing the legal rules that once formally embedded skepticism of rape complaints, and then by highlighting a contemporary outlet for the skepticism in police and prosecutorial responses to sexual violence. Throughout this migration from law to law enforcement, the paradigmatic rape accuser has maintained her hold. She is a woman who falsely reports rape because she is vengeful, regretful, or too intoxicated to know better. She invites rape. She needlessly complains about rape when the perpetrator is an acquaintance. Often when police officers and prosecutors confront an allegation of sexual violence, they unduly doubt the trustworthiness of the complainant and the plausibility of her account. In the main, reports of sexual assault are met with skepticism born of prejudice. Absent a true reckoning with how sexual assault victims are perceived by those with the power to dismiss their claims, future reform efforts, both on and off campus, will inevitably be constrained. Theorizing credibility discounts as epistemically unjust represents a significant conceptual advance. Identifying the systemic downgrading of credibility as itself a problem with a specific name and developed theoretical underpinnings, facilitates an understanding of all that is at stake when rape complaints are unduly disregarded. This discussion has centered on primary epistemic harms, which have until now mostly escaped attention. Epistemic injustice also undermines norms of equal citizenship, especially when the downgrading party is a state actor and where the speaker's account is not just any account, but one that tells of violation. These concerns are distinctive and separately deserving of our attention. Within the realm of sexual violence and beyond, perhaps especially in the context of racial oppression, contemplating the political dimensions of epistemic injustice has the potential to enrich a newly revived national conversation about the full implications of inequality. Our construction of knowledge is bound to reflect the hierarchies in which we are situated. In a more just world, each of us would be able to meaningfully contribute to the constitution of a collective reality, which only then could be transformed.